And today we have a very special guest, a good friend to our organization as well, who's helped us with so many other issues too, religious liberty, pro-life issues, you name it. Ryan Bangert, we're so happy to have him on the show. Ryan, welcome to the Texas Values Report.
Hey, thank you for having me, Mary Elizabeth. It's a pleasure to be back with you again.
Yeah, thank you so much for joining us. And, some of our supporters know who you are. We've had you on the show before, but for those of you who might not know Ryan, I just wanted to read a little bit of his background. Ryan Bangert serves as Senior Vice President for Strategic Initiatives and Special Counsel to the President at the Alliance Defending Freedom. He oversees ADF's regulatory practice, government relations, and corporate engagement teams. He also advises executive leadership with strategic initiatives and appears as counsel for ADF clients. Before joining ADF, Bangert served as Deputy First Assistant Attorney General and Deputy for Legal Counsel in the Office of the Texas Attorney General, and in those roles he oversaw the state's Special Litigation Unit, which handled critical litigation against the federal government and oversaw multiple divisions within the office. So thank you so much for all of your work over the years, but we're going to talk about a very niche issue, a very popular issue that has been talked about in the news amongst media and amongst people who might not even align with us who have gotten involved in this issue, which is the Save Women's Sports issue. And Alliance Defending Freedom has been doing a lot of great work. They were probably one of the first organizations that I remember that filed a lawsuit on behalf of female athletes. So we're really excited that this issue is at the U.S. Supreme Court. There's some things that are common sense that you'd say it shouldn't be litigated, but we're happy that the court is taking up this issue and hopefully we can get some good precedent on it. Now, Ryan, some people are aware that this issue is at the Supreme Court of keeping men out of women's sports, protecting women from being forced to compete against men. But, some of our listeners might be a little confused or not really keen on what's happening because they know we have our Texas laws. They know that those laws haven't been challenged. So can you provide our listeners on background on the cases and what is before the Supreme Court on Tuesday?
No, I'd be happy to do so. And 27 straight states today have statutes that protect women's sports.
Wow.
Texas is one of them, obviously. The very first one that passed a women's sports law, though, was Idaho, all the way back in March of 2020. And the very next month, in April, Idaho was sued by the ACLU. And the ACLU argued that Idaho's law protecting women's sports violated the U.S. Constitution, the Equal Protection Clause, to be specific. The ACLU also argued that Idaho's law violated a federal statute called Title IX. Now, many of your listeners probably recognize Title IX a little bit. That's the federal statute that for years and years has required universities to treat women fairly when it comes to all sorts of things, including funding for women's sports. What the ACLU argued, however, is that Title IX required Idaho to allow biological men who identify as women to compete in women's sports. And they made the same argument with respect to the Constitution, that the Equal Protection Clause required states to allow biological men who identify as women to compete on female sports teams. Now, shortly after Idaho passed this law, West Virginia did the same, and they also were sued by the ACLU. In both cases, the ACLU is ostensibly representing a male athlete who identifies as female and claims that they've been unable to participate in women's sports because of these laws. Now, ADF joined with the Attorney General in Idaho, Raul Labrador, and the Attorney General in West Virginia, now is J.B. McCuskey, who both very courageously defended their state's laws against these lawsuits. And ADF came alongside them representing female athletes in both states, Lainey Armistead in West Virginia, Maddie Kenyon, and others in Idaho. And the argument, of course, was that the ACLU was getting everything completely wrong and completely backwards. The Constitution and Title IX do not require states to ingrain in their law lack of fairness toward women. Our argument is simple. Women deserve equal opportunity, fairness, and safety in all aspects, including in sports. And the Supreme Court should recognize that and should also recognize the basic biological fact that men and women are different. And that because of that difference needs to be respected and recognized in the law so that women can have a fair and level playing field when it comes to sports.
Absolutely. We really appreciate your work, and we appreciate the work of Barbara Ehart, who was the state representative who passed that law in Idaho. She was actually very instrumental in Texas. You may remember her coming to testify at some of the Texas hearings. She had like a very unique way of addressing our Texas legislators that I think everyone appreciated. But she's been in this fight for some time, really being supportive of this law. I think she'll be at the rally Tuesday.
Mhm.
But it's very interesting to see that since Idaho, 27 states do have these laws protecting women in their sports. And very sad to see that the ACLU thinks that they can twist Title IX because some people who watch our show may be aware we did a series on the history of Title IX, and we think about why Title IX was passed in the first place. And even the woman who decided to present this legislation in Congress, it is to make sure that women have access to sports and education. And that's why we have these sex separated sports. But very interesting times we're in where people can twist that or redefine it. And I won't bring up the previous administration because we're so past that now. But it's very interesting to see some of the arguments and really hoping that we get a good opinion, which I think we will on Tuesday. Now, ADF is providing counsel in this case. You mentioned that ADF is involved in this case, but ADF has also represented a large number of female athletes across the country. I can't even count how many clients that maybe you have represented, from girls who've run track to maybe girls who've done shot put or wrestling. Can you share some of the stories of some of the clients that ADF has represented?
Of course. I mean, it's been incredible to see just the impact that women's sports makes in the lives of women all across the country. Participation in high school sports by women has increased 11-fold since Title IX came into existence. Women now make up nearly half of all college athletes. And what's most interesting is that 94% of senior female executives played sports. So there's no denying that athletics plays a major role in the lives of women who participate in these sports. And yet, if you force women to participate in sports against men, it causes tremendous unfairness. We look at our athletes in the state of Connecticut, one of the very first cases involving a challenge, in this case to a Connecticut rule that forced schools to place male athletes on female teams. We had instances where several of our athletes were competing in track and field and losing over and over again, superior elite female athletes, losing over and over again to male athletes who, had they been competing in the male division, would have been mediocre at best. And yet, when these male athletes switched over and competed against female, because of these inherent biological differences, they were able to take the podium and take first and second prize multiple times, denying these female athletes who had worked so hard for many years to hone their skills and hone their craft opportunities to enjoy the fruit of their labor. And that's not fair. And if you look at the purpose behind Title IX, it was to ensure fairness and fair opportunities for women. And I think, as you just mentioned, it's so disingenuous for groups like the ACLU to argue that Title IX requires this unfairness, requires states to actively deny women opportunities for a level playing field. It's a complete twisting of Title IX. We have stories, we can talk about stories from Idaho where women were denied opportunities to advance. In West Virginia, the client that the ACLU represents, b.p.j, has taken hundreds of opportunities from female athletes. And so the results is not just a hypothetical problem. The results of this policy has been to ingrain unfairness all across the country and to deny female athletes the ability to enjoy the fruits of their labor. And as I just mentioned, this is not just about some people say, well, it's just sports. What's the big deal? No, it goes far deeper than that. It's about safety. It's about privacy for these female athletes when they walk into the locker room, knowing they can feel safe when they walk into these locker rooms. It's about giving them the ability to enjoy the fruit of years and years of faithful labor. to improve their skills. It's about giving them the opportunities to advance beyond athletics into their careers. So this stretches across an entire spectrum and an entire lifetime for these female athletes. And quite frankly, it goes even further beyond sports because these types of policies that disintegrate the distinction between men and women are now being applied to private spaces, restrooms, locker rooms, to facilities that are designated for women only. Think shelters, women's prisons, shelters for women who have been assaulted. So all of these types of distinctions have been eliminated, and that causes women to suffer a great degree of uncertainty and lack of safety. And that is not an appropriate policy, and it's deeply unfair to women.
Absolutely. And you're absolutely right about how this issue is an issue of safety as well. What happens when the women go to the locker room, when they step off the field or out of the pool? We had Riley Gaines talk about how Will Thomas, didn't just compete against them and then go to the men's room. He went to the women's locker
Right.
room. So it's an issue of privacy and safety as well. And we'll have a special episode later today with Brooke Slusser, who talked about not only did she have to compete against a male athlete, she had to share an apartment with him, a hotel with him, a locker room with him, all of these spaces. So it's an issue that expands so many different areas of a woman's life, especially if she's forced to share these spaces with a male unjustly and unfairly. Now, over the past years, we've had some interesting opinions in related to the issue of biological sex. We think about Bostock on the issue of Title VII, but then we also think about Scrimeti, where Justice Barrett actually had an interesting opinion saying that gender identity is not an immutable characteristic. So, what are your thoughts on what will be said about the differences between men and women on Tuesday?
Well, you're absolutely right that in the Scrimeti case, if your listeners, I'm sure you have many faithful listeners who have heard you talk about the Scrimeti case, a case that arose out of Tennessee. And the question was whether or not Tennessee could place restrictions on medical professionals who were trying to provide what they call gender transition or gender change procedures for minors, kids who are under the age of 18, who were wanting to take cross-sex hormones or puberty blockers that science has demonstrated have permanent effects on their bodies and could render them unable to have children in the future. And these children were being really railroaded and forced into these procedures without really understanding the long-term consequences of what they were doing. And the Supreme Court held that the state of Tennessee, as well as a number of other states, had the right to do that, that the Constitution did not prohibit them from providing these kinds of common sense protections for children. Now, let's switch over to sports. We have the case coming up on Tuesday. The argument that the ACLU has made is that the Equal Protection Clause and Title IX require that males who identify as females be treated just the same as biological females when it comes to sports. And what I think is very interesting about these cases is the factual evidence in the record demonstrates exactly the opposite. ADF was very involved in the b.p.j case at the trial court level. And what was very interesting about that case is initially when the ACLU filed the lawsuit, the trial court judge in that case granted an injunction, basically told the state it was not allowed to enforce its law while the case was pending. The state of West Virginia and ADF partnered together to conduct discovery, basically to develop a factual record demonstrating that West Virginia's policy protected fairness and safety for women. And over again, what you saw from this discovery was experts, medical professionals saying that yes, there are immutable differences between men and women, that those differences matter, that they make a difference when it comes to athletic competition, that there are deep unfairness. There's a deep unfairness in forcing women to compete against men. And this trial judge at the end of that period of discovery reversed his injunction and entered judgment for the state and remarked that the facts compelled him to do so. The facts were so overwhelming. So I think that the ACLU is going to make a bunch of legal arguments at the U.S. Supreme Court. But what I'll be very interested to see is how the court deals with the factual record in this case that demonstrates factually using science that there is deep unfairness when men are allowed to compete against biological women. And the facts really speak quite loudly, I think, in this case. And I think ultimately that will have quite a bit to do with how the court resolves this matter.
Absolutely. And I feel like the science has been kind of the key indicator in getting public opinion on our side. You know, when you bring out just the mirror images of some of the male athletes standing next to the female athletes, but also a lot of good work that organizations like Icons and Independent Women's Forum putting out some of their reports on the differences of lung capacity, muscle mass, bone structure, a lot of things that are from birth kind of developed at a different level for a male as opposed to a female. That doesn't even take into account puberty or not. I think b.p.j, I think the young man probably was a little younger. And so you have ACLU and other people saying, well, they're young, or they haven't gone through puberty, or they unfortunately went through that process of stopping puberty. But there's so many differences that are innate and inherent to where women are at a disadvantage when they compete against these men. So it will be interesting to hear their opinions. One opinion I'm interested in hearing is of one justice who, you know, has famously been flagged for saying she does not know what a woman is or can't define a woman. So I wanted to ask a fun question. I said, if you had to write the dissent for this particular justice, what do you think the first two sentences of that dissent would be?
Well, it's that's a really good question, and I
Okay.
think those two sentences would likely have to engage in some real sophistry because ultimately you're going to have to deny the facts and the reality on the ground that men and women are different, and that gender identity can't wipe away those differences or eliminate the biological reality that men have a distinct advantage over women when it comes to sports biologically. And I know that you're talking about one of the current justices,
Right.
but I want to point back to a female justice from a bygone era, Ruth Bader Ginsburg, a famous champion for women's rights, a very strong champion for equality of women. And she said, and very famously, she said, quote, persons, men and women are persons of equal dignity, but they are not the same. And I think that's very telling. Ruth Bader Ginsburg understood that men and women, both created in the image of God, both of equal dignity, but created differently. And the U.S. Supreme Court has even recognized this in its writings. The court has said that men and women should be treated with equal dignity under the law, and that there are inherent differences between men and women. And these differences are not cause for concern, rather, they're cause for celebration, in the words of the court. And
Absolutely.
so I think if we get that kind of a dissenting opinion, which we may, I think that it will have to deny everything that I just said, which is that men and women are created equally but differently. And those differences are cause for celebration, not for concern. And that gender identity is something that cannot wipe away or eliminate those fundamental differences rooted and grounded in biology and ultimately in the way that God created us, which is, we go back to the book of Genesis, God created them male and female. And that very fundamental reality ultimately is what's at stake in this case.
Yes, absolutely. Well, we're out of time, but it's been wonderful speaking with you, Ryan, about this case and about the issue of protecting women from being forced to compete against men. We're so excited about Tuesday. We'll have members of our team there, so I will see you Tuesday at the United States Supreme Court.
Well, bring your jacket because it's chilly here in DC where I am, but we'll
Okay,
look
will
forward to
do.
having you.
Okay, for sure.
Take
I'll
care.
remember. All right, thanks so much, Ryan.